All right, thanks for coming, everybody. My name is Pete Hirth. I'm a member of the Plan Commission here in Sevastopol. Victoria Serenich is here, Vic Weidman, Bob Papke, and our chair is John Stavinus. Daryl Von Berg, where's Daryl? Daryl's here as well. He's one of our members. Mariah and Kay from the Door County Planning Department are also here. The way this kind of came to be, I'll give you a quick breakdown before I turn it over to them for a PowerPoint presentation. But about 5 years ago, the town was responsible for developing a smart growth plan. As part of that smart growth plan, each town had to implement it. It kind of projected what the town goals were, where development in a town would happen, where it would not happen. That process took a couple of years. There was public hearings many of you were probably involved with. Based on that, we do have a smart growth plan that was adopted a couple of years ago, and that's kind of our guide as far as what our plan commission should and should not be doing. Part of that smart growth plan that we implemented states that we're supposed to come up with ordinances regarding land division. The town of Sevastopol currently is under county zoning, and it will continue to be under county zoning. So the county planning department implements zoning rules. You pull your building permits or your land division, everything goes through the county. So Mariah and Kay are very well versed in exactly what it takes to divide land and what the process is as far as going forward. One thing that the smart growth plan dealt with that I know was a hot topic years ago when we first went through the process was the 20-acre rule in Sevastopol. Right now, the way it's stated is if you're in general ag zoning classification, you can divide your lot into 20-acre lots. So if you have a 100-acre farm, you could do 5 20-acre lots. The position of the smart growth plan, and I'd say the majority of us on the plan commission, was the 20-acre rule. While the goal originally was preserve open space, keep Sevastopol rural, what we feel is happening, at least my personal opinion, is if you take a 100-acre farm and use it up every time you need 5 houses to be built in Sevastopol, you may be defeating the purpose rather than saying, let's give people smaller zoning districts so that if the demand over the next 20 years is 30 houses in Sevastopol, you concentrate them on a couple farms rather than eating up a whole bunch of farms. So that's kind of how our discussions came to be. One thing we looked at doing was creating our own conservation subdivision regulations, which would allow smaller lot sizes, setting aside open space, preserving the open feel of the town by giving a higher density, so maybe it made sense for some people to create more lots in Sevastopol. One of the things we hear a lot is the school, how it's hard to have affordable housing anywhere near school. Enrollment numbers, as we know, are down. We thought if we could provide a means of having more affordable lots in the town, it might save the school. So that's one of the talking points. My background, I'm a civil engineer with Bodwin Incorporated. Kind of how I got invited to be on the Plan Commission, just a background of subdivision work. In the last 10 years, especially during the boom, our company did probably 20 conservation subdivisions down in southeast Wisconsin. So I was involved in the process down there as far as how they turned out, what they looked like, what the saleability of the lots were. So we tried to bring a little bit of that here. What we decided after looking at doing our own subdivision ordinance was that it was just too complicated and it'd be too difficult to enforce our own subdivision rules since we are under county zoning. So the discussion came back to the Plan Commission of, rather than starting over and reinventing the wheel, we should probably just pick a zoning classification that already exists under county zoning and try to pick areas of the town that make the most sense to use those smaller lot zoning classifications. So when we sat around our Plan Commission table, the discussion started with, well, what do you think? Should we tell everybody in the whole town that they could divide up their lots smaller than 20-acre rule? Should we tell nobody they could? Or should we promote a certain area to be developed? So the reason you're here is probably because you received the map in the mail and the letter. So what we decided as a group, and it might be right, it might be wrong, and that's what we're here tonight to figure out, is we took a mile from the middle of Institute, a mile from the middle of Valmy, and a mile from the city limits, and said those would be the 3 areas that we think could support smaller lot sizes, could support better pricing on lots, so maybe more people would move to the community and support the school and everything that goes along with it. So if the property you own is currently zoned either for small lots or commercial use, you would not have been sent the notice. A lot of these areas already are zoned that way, so there'd be no change in any of that. And what we're trying to do tonight is figure out if, through the discussion tonight, and the questionnaires that the county can have you fill out, is this right, wrong, or do half the people are in favor of it, half the people are not? If everybody says, forget it, this is terrible, let's keep the 20-acre rule, that's fine. We'll, you know, it just, we need our direction whether or not we proceed any further with this, or if this is the end of it, or if people are interested. So that's kind of the story. The county will give a presentation here. If you have questions, you know, the entire board will be here. If you have questions now, we can do that, or if you think it'd be beneficial to run through the PowerPoint, we can do that first. So I guess whatever you think, Mariah, as far as.
It's up to you. Does anybody have any questions of Pete before we get started? No? Okay. I'm Mariah Goode. I'm the director of the County Planning and Zoning Department, and with me tonight is Kay Miller, the zoning administrator who handles Sevastopol, zoning and land division and other land use related matters. And what we're going to be doing, well, and Pete gave you, I think, pretty good background on what the planning committee has been doing for the last couple of years. And when we started meeting with the planning committee in, I think it was February, we basically came in to offer technical and information and assistance. So these are the rules you have now. These are the options that people have now. These are things that you could look at doing, and here's what the effects of those would be. And as Pete said, they decided to focus on potentially rezoning in a couple of different areas. There are some maps around, which now, of course, we're going to be blocking, but you'll have time after our presentation to look at them. We've got the existing zoning map for Sevastopol. We've got the maps that went out in the mail for the 3 areas that were potentially being targeted for rezonings. We have the future land use map for the town of Sevastopol from the town's comprehensive plan. And then I also brought the future land use maps for the whole county, just in case you wanted to kind of see what Sevastopol looked like compared to the other towns. Those maps, the county-wide 3 maps up here, are from the county comprehensive plan. So the naming and the color coding is different than the town's map. But when we created that county map, we took all of the town maps and kind of came up with one unifying system. So tonight, what Kay and I are going to do, depending on how many questions there are, and please feel free to interrupt us along the way, because we don't want anybody to be confused about something and then not understand the next couple of slides after that. My guess is that our PowerPoint's probably going to be half an hour to 45 minutes. We're going to give some background information on the existing prime agricultural, countryside, and estate zoning districts that are what the bulk of the interior of Sevastopol is zoned right now. So as Pete said, those of you that are in a small lot district wouldn't have gotten the mailing. You're obviously welcome to be here, but those of you that got the mailing, unless we made a mistake, you're in one of those 3 districts. You're either prime agriculture, countryside, or estate. So we're going to tell you about the subdivision options for those districts now that exist, including, Pete was talking a little bit about conservation subdivisions, so we'll show you what the options are right now. We're also going to walk you through a little bit about the small estate district. That's different than the estate district, because that's the district that the town is thinking of potentially rezoning some of these areas to, and that's a smaller residential district. And we'll compare that to that prime agricultural, that countryside, and that estate district, so you can get an idea of how they're different from each other. We'll talk about non-conforming uses and what might happen if rezonings are pursued to some uses that are out there. We'll walk you through the process-related steps on the county's end, and the town should pipe in at that point as far as how they foresee the next couple of months going. And then we can have more questions and answers at the end. And then at the very end, what we would like you to do before you leave, if you're one of the people that got a mailing in one of those areas, we want you to come and see either me or Kay. I think one of us will probably be at a table up front and one in the back. And we want you to fill out that form that Pete was talking about, because we want to make sure that we know from everybody that's here which parcels are yours, or just cross-reference our list, and how you're using your property, so that we can give information back to the town as to whether or not you would be impacted by a rezoning. And you can obviously give us your opinion as well too. You can say, I'm not interested, or we are interested, or whatever, and we'll relay all that information to the town. So.
I guess just to interject, the one thing we kind of decided was the small estate zoning, which right now allows 1.5 acre lots. So that's kind of why we came up with the small estate. So that's kind of the direction we're pointing right now. You know, the big question is the mile circle too big or too small? And, you know, one of the questions I forgot to talk about a little bit was the tax implications. You know, obviously the first thing you think of is, oh my God, if I change my zoning, is my taxes going to get increased? And the answer to that, from everything we've talked to appraisers and assessors, is no, it shouldn't. If you're agriculturally using your land and it's zoned small estate, you're going to still be charged as an agricultural rate. So once you develop it into lots, certainly you would be charged as the lot values. But just having the zoning and continuing agricultural use until such time you do it shouldn't impact your taxes.
Okay.
Okay, well, interestingly enough, I usually do a shoreline zoning talk for some of the lake associations in here, and one of the first things I always tell them is pretty proud that Wisconsin was the first state in our country to enact some type of zoning. Can't remember the date quite off the top of my head, but I think it was in the 1950s. But in June of 1968, essentially the state of Wisconsin mandated that counties enforce a shoreline zoning. Essentially, Administrative Code NR 115 came into effect, and essentially the state said that the counties were going to enforce and administer shoreline zoning. In September of 1976, Sevastopol adopted county zoning townwide. So comprehensive zoning came into effect for Sevastopol, and that's essentially when the interior of the town also became zoned. That ordinance was in effect until we did an ordinance rewrite in 1995, and that's the current zoning ordinance that's in place now, and that replaced the previous ordinance that came into effect.
So as Pete already said, about 5 years ago, the town went through its comprehensive plan development process, and you often hear them referred to as smart growth plans. That was a state statute that was passed in 1999 that said originally that any municipality that was going to do anything that had anything to do with land use had to do one of these plans. And it outlined all the things that needed to be dealt with in those plans, including affordable housing and, you know, things related to your utilities, transportation, all that kind of stuff. As part of, and the county had to do a plan as well. As part of the development of the county plan, like I said earlier, we took all the town future land use maps to create a county-wide future land use map. And as we did that, we overlaid on top of that map what are called the core areas. That's a concept that was in the old, in the 1995 plan that was adopted with the current zoning, where it targeted areas in each of the towns where the towns wanted to have development. So it's supposed to be a mixture of residential, commercial, institutional, your more dense, more intense uses. So those core area boundaries were provided to the towns to look at when the county was adopting its plan in 2009. So if you get a chance later to take a closer look at the zoning map or at those future land use maps for the county, you'll see little purple boxes around like Institute and Valmy, downtown Bailey's Harbor, downtown Jacksonport. And again, those core areas are where development is really supposed to be targeted. And as Pete was explaining earlier, that was how they picked where they wanted to look at doing the mailing and the potential rezonings at the town level, because in Sevastopol, Institute and Valmy are designated as your core areas. The area around the city is not designated as a core area, but on the future land use map, a fair amount of it is shown as residential, and a lot of it is already zoned for residential.
I just wanted to show you the current existing zoning map, thanks. The yellow zoning district here in the middle of the town, which is pretty much the bulk of the interior, is the prime agricultural zoning district. And just to kind of briefly go around the map, the turquoise is the wetland, the yellow is a small shoreline zoning district. The purple or periwinkle here is, actually the blue is the estate, which is a 5-acre zoning district, and then the small estate is purple on here. And then as Mariah was talking about, these are the core areas outlined in the purple boundaries. But essentially right now what I want to talk about is the prime agricultural zoning district, which is yellow on that map. So essentially this slide is showing the purpose and intent of the description from the county zoning ordinance for the prime agricultural zoning district. Just kind of a note of interest, of the 17,500 and some odd acres zoned prime agricultural, 12,559 of these were assessed as agriculture in use in 2012. So just, I know everybody, it's up here, but I'm going to read it. This district is intended to maintain and preserve agricultural lands which have historically demonstrated high agricultural productivity. Lands eligible for designation shall generally include those designated as primary or secondary farmland in the Farmland Preservation Plan. This district is also intended to provide owners with additional management options by allowing limited residential development, but with residential density limits and other requirements set so as to maintain the rural characteristic of this district. These purpose and intents essentially help the county for planning purposes if there would be potentially any rezonings or a certain type of use that was being proposed in these districts. Our oversight committee also uses this in those types of public hearings. So we have a purpose and intent for each of the districts that we have. The countryside zoning district, which was reflected on this map in the gray. Oh, maybe this again. We have some of this countryside, which is a 10-acre minimum zoning district. The prime agricultural was a 20. That is surrounding a little bit of the core area, and then we have it coming down off of essentially Forest Road and to the south. But this district is intended for mostly rural areas of the interior of the county, where a mixture of low-density, residential, agricultural, and rural commercial activity exists or is desirable. This district provides for a residential development at modest densities consistent with a generally rural environment and allows for non-residential uses which require relatively large land areas and which are compatible with surrounding rural land. This is kind of a transitional district between agricultural districts and then getting more to the developed areas. So you have this prime ag zoning district, this 20 acres. You have smaller lot districts bordering the city or some of the core areas. And in between that, you kind of need a transition zone. And this countryside district kind of serves as that transition zone, requiring that 10-acre district. And then the purpose and intent of the estate zoning district. This is our 5-acre zoning district, and this district is intended to provide primarily for single-family residential development on large lots. Lot sizes of at least 5 acres are required for new lots. The low density requirements are intended to provide for areas where the presence of vegetation and open areas help create quiet and visually attractive residential areas. So these 3 zoning districts are primarily what you have if you got one of the letters. So that's what they're looking at in terms of potentially rezoning it to small estate.
Now I'm going to walk you through the land division options in those 3 districts that are available. As Pete said, the basic rule of thumb in that prime agricultural district is that it's 20 acres for a new lot, if you're going to create a new lot. Now, it should be noted that there are dozens of lots, if not hundreds, I don't even know,
Sure.
in Sevastopol that are in that prime agricultural district that are smaller than 20 acres. And 99 times out of 100, those are probably grandfathered, legal, buildable lots. So just, you know, if somebody has a lot that's less than 20 acres already in prime agricultural, zoning, it's still likely a buildable lot. So in the prime agricultural district, you are allowed to have one single-family residence per lot. You can also have what's called a secondary dwelling unit. This is a use that's new to the zoning ordinance that was added about 2 years ago. I'm not going to go into great detail, but essentially if you have a single-family residence, you are allowed to build a secondary dwelling unit as long as it's under 749 or under 750 square feet and is maintained in ownership with the house and is not rented for less than a period of 30 days. So you can have your house on your prime agricultural lot, and you can have a secondary dwelling unit. You can also have a temporary manufactured home for the parent, the child, or an employee of your farm operation, if you're a farmer, and this is in addition to your house, that you can have that. And you can have a temporary manufactured home in addition to your house, which would be an accessory unit if you have disabled or infirm dependents, either parents or children or siblings, I guess, probably. So those are the basic options. Yes?
So on the one single-family residence per lot, secondary unit, if the secondary unit is connected to the same house,
You can either be
it would
connected.
also be considered that would be considered a secondary dwelling, correct? If it had all of the capabilities of a standard dwelling, kitchen, bathroom.
Right, that new secondary dwelling unit option, it can either be attached to your house or created within your house, or it can be a detached structure. There's just certain rules you have to meet about setbacks and size and the restriction of the sale and rent of it. Yes?
Would you please define the temporary?
Well, actually, you're talking about for the manufactured homes, there isn't really a definition. As long as if you're a farmer, if you've got a parent, a child, or an employee of your farm living in that manufactured home, it can be there for years.
Is this what we commonly call a trailer?
Yes, single wide.
Yeah, yeah.
Yep.
And the same thing, if you had the disabled or infirm dependent, as long as they're living there, you can have that, you know. No, that's different. That's the secondary dwelling unit. And the secondary dwelling units aren't a temporary use. You can build it or create it and have it forever. So if you're in the prime agricultural district and you have 21 or more acres, so if you own 21 plus acres, then you have a couple of different options in addition to the ones that we just walked you through. So if you've got 21 or more acres, and you have a farmhouse that was built before 1976, before Sevastopol adopted county zoning, and if you're farming, you can split your house off onto a 1 acre lot, as long as the leftover piece is 20 or more acres. So if you're a farmer and you've got 21 or more acres, if you meet the requirements as far as how old your house is, you can split off your house. Like if you wanted to sell the rest of your farmland, or you want to continue farming it, but you want your house on a separate lot for some reason, you can do that. You can also, if you're farming your property and have 21 or more acres, you can create vacant lots that are as small as 1 acre, as long as the leftover chunk is 20 or more acres, if you're going to build a residence for, again, a parent, a child, or an employee of your farm. So you've got a couple of different options in that district if you have more land and if you're farming your property.
One of the primary reasons that split off option came for that single family residence, as farmers were getting older in age, they lived in a home that they had for the majority of their life, and they didn't want to have to move if they didn't want to continue farming 100 or 200 or 300 acres. So that split off option, as long as there was more than 20 acres, you needed 21 at least, it allowed somebody to stay in their home and sell off the land either to somebody who wanted to build a home or consolidate it with another farm operator who was still farming. So,
does anybody have any questions about those before I move to the next two? Okay, so yeah, you've got several options. You can always have the single family residence. You can always have the secondary dwelling unit. If you're a farmer, you can have a temporary manufactured home for parent, child, or employee. If you're not a farmer, but you've got an able or disabled or infirm dependent, you can have that temporary manufactured home also. And again, if you're farming and you've got 21 or more acres, you have the ability potentially to split off your house or to create some vacant lots. So this is the countryside district, and the concepts are all the same. So in the countryside district, the basic lot size requirement for new lots is 10 acres. Again, there's probably a lot of what we would call grandfathered lots out there that are smaller than 10 acres, but that would be considered buildable. You can have one single family residence per lot. You can have one secondary dwelling unit per residence, and you can have those same temporary manufactured home options. If you have 11 or more acres, again, you can split off the 1 acre lot with your house, or you can create a 1 acre vacant lot for your farm employee or parent or child. Do you do duplexes in countryside? Yep. The other thing you can do in countryside is a regular old duplex is allowed. Mm-hmm. So if you wanted to build a duplex, which is 2 dwelling units that are attached, if the secondary dwelling unit wasn't going to meet your needs because you didn't want it to be under 750 square feet, you can build a duplex in countryside. And then finally, the same thing for the estate zoning district. So the basic rule in this district is that for new lots, they need to be 5 acres. Again, there are probably a lot of grandfathered lots out there. Again, you can have a single family residence, you can have a secondary dwelling unit. If you meet the requirements, you can have the temporary manufactured home options. And again, if you've got 6 or more acres, you've got all of those options plus a couple of extra if you're farming that property. Or if somebody's farming that property, I think. So. Okay, so those are all the basic options. You also have conservation subdivision options, and these are in the county zoning ordinance. We've had conservation subdivision rules for years and years, but we just rewrote them at the county level, and the county board adopted them about 2 years ago, I think. And the basic concept behind a conservation subdivision is that instead of taking what people usually refer to as a cookie cutter approach to dividing up your land, as Pete said earlier, you kind of group your lots on smaller lots, group them together, and you have open space that remains that way. And in exchange for doing that, for setting aside that open space, whether it's agricultural or wooded or just open space, you get extra lots. So if previously you were in a 5 acre district and you owned 40 acres, the normal land division people would be to draw 8 boxes on your 40 acres. If you were going to do a conservation subdivision development, you could make those lots much smaller, get more than 8 as long as you set aside some open space. So these are the numbers from the county zoning ordinance that relate to the districts that we're talking about tonight. So you've got the prime agricultural, the countryside, and the estate districts, and now we're also throwing that small estate district in there as well so that you can see how those compare. Yes?
Yeah, Mariah, I'm considering doing this property that I own, and it basically allows a 20 acre lot to be a 10 acre lot, correct?
In terms of the density, I'll walk you.
For comparison purposes. So basically, in prime agricultural property, if you adopt this, you're actually allowed to have 10 acre zoning as a way of doing it versus 20 acres in effect now.
In terms of the density, and I'll walk you through an example. So what Mike is saying, so right now, these 2 columns relate to what we call the conventional subdivisions. So the slides that I just walked you through, these are the lot size requirements for those zoning districts. And these are the number of dwelling units that you get per acre when you do the math. So if you get 1 dwelling unit for 20 acres, that comes out to this number, 0.05. And then on down the line. If you were going to do a conservation subdivision, what Mike is saying is that, so you're in prime agriculture, and you still have 20 acres, but now, instead of getting 0.05, which translates to 1 house for your 20 acres, you can get 2, because you take this 0.10 and you multiply it by the 20, and you get 2 residences. Now, the way that you get to do that is that you are required to take 80% of your 20 and set it aside as open space. You can still own it and farm it. You can sell it to the Nature Conservancy. You can sell it to your neighbor. You can sell it to a neighboring farmer. Your 2 lots that you're creating, maybe those 2 people want to own it in common and have some hiking trails out there. As long as it's permanently dedicated as open space, you can do that. And so what that translates to in this column is the increase in dwelling units that's allowed. So it's 100, if you utilize that conservation subdivision option in prime agriculture right now, you're essentially getting 100% more houses than you would have previously. So instead of 1, you get 2.
In exchange for setting aside the 16 acres of preserved open, permanently,
Permanently,
right, there would be
yeah.
restrictions that would be placed on the deed, but
Yeah.
that would be a bonus in order to do it.
Yeah. So I won't walk you through an example for all of these
No.
districts, but so in countryside, again, normally you have 10 acres, you get 1 house, which if you multiply 0.1 times 10, you get 1. If you're doing a conservation subdivision, you take your 10 acres and you multiply it by 0.2. So now you're going to get 2 houses in your conservation subdivision, as long as you set aside 80% of that land for, again, farming, recreation, parkland, whatever. And then the other thing to keep in mind, too, is that those residences that you're creating in a conservation subdivision are single-family residences, so they have the ability, or the owners have the ability, if they want, to do a secondary dwelling unit as well. Is that clear to everybody? I know it's a lot of numbers. So, okay.
Question.
Yes.
So on, if the land that's being used already has restricted uses applied to it, such as wetlands and so forth, how does that factor into this? Does that, can that be used as the set aside?
Sure. It can be used as the set aside, but it doesn't count towards the density bonus.
Yeah, so you can, yeah, if you've got wetlands or land that you're not farming or, you know, not using for whatever reason, you can set that aside as part of that. And the conservation easement that would be recorded against the land, we've only had a couple people do them so far, but it's relatively simple, and it really is largely up to the property owner what they want to do with the land, as long as it's not going to be developed. And then the county is named as the monitoring entity in perpetuity for that open space.
So if I had a 20-acre lot, 25% of it was wetland, technically I only have, I'm really working with a 15-acre lot at that point when I use the conservation space required.
We'd have to check on that.
I might have to look at the ordinance.
Yeah, we'll have to
and see
check on
whether-
that one.
Yeah, I think we changed that.
We
I think
might
that's
have,
what
yeah.
would affect your dwelling units per acre.
Right.
You'd be reducing the total
Yeah,
available.
essentially you need 20 acres of upland, but we might have a provision where if that's the case, like you only had a 20 and you had some uplands, that we're going to give you the benefit, the bonus as well, but that's something we'd have to check on.
I'll look that up while she's
Okay.
talking through the next couple slides.
So essentially, now we come to the small estate zoning district, and this is the zoning district that is being proposed for the potential rezoning that the town would like to potentially pursue. And this district essentially is intended to provide primarily single-family residential development on lots smaller than the 5-acre estate zoning district and the Heartland, we don't have any Heartland in Sevastopol here districts, but larger than the small shoreline districts, which are SF20 and SF30. Lot sizes of at least 1.5 acres are required for these new lots. This district is intended for residential areas where high density is inappropriate or undesirable, and for transitional areas that are beginning to convert from undeveloped land to residential uses. If you want to hit the slide. Now, okay, so under county zoning, we have a zoning ordinance, which is this, and when we can't fall asleep at night, we read this. But there's a lot of stuff in here, but one of the things that's in here is a chapter that has the table of uses. It outlines the zoning districts across the top, and we have well more than 4 zoning districts, but for the purpose of the slide, we're showing the 4 that we're talking about. But we have the zoning districts across the top of the chart, and then we have designated uses down on the left. In the chart, if that use is allowed in a zoning district, there's going to be a P. Essentially, it's permitted. It requires a regular zoning permit some of the time. If there's a blank in the chart, it's not permitted. It's just a use that is not allowed in that zoning district. If there is a C in the chart, it's a conditional use permit. That requires a public hearing before the Resource Planning Committee. That is potentially a permit that is not automatically granted. It could be granted or denied, If it's granted, it could be with conditions. So what we did is we wanted to do a chart that shows the major differences between the 4 zoning districts that we're talking about: prime agriculture, countryside, estate, and small estate. We eliminated the uses that are allowed in all 4 districts. We don't want these charts to go on forever, but they might be authorized by a different permitting procedure. But what we did was then we also eliminated some of the more unlikely uses, such as airports or fire, police stations, public highway garages. So this chart isn't a complete list, but we wanted to give some examples. This is why later on you coming to see us and letting us know how you use your land would potentially be important with regards to a rezoning. In the prime agriculture, the countryside, and the estate zoning district, and I'm going to pick the big one because we saw out of the 17,000 acres that's zoned prime ag, 12,000 were in some type of ag use. Agriculture, and these are separate uses here, but agriculture is permitted in the prime ag, countryside, and estate zoning district. It is not allowed in the small estate zoning district. So that would be an example of a use that potentially could have impact if lands were rezoned to small estate. Let's see.
Do you want me to go to the next one?
Yeah, go to the next slide.
Quick answer to the question from the gentleman in the back.
Yeah.
You're right. Kay spoke correctly. When you're doing a conservation subdivision, you can use the wetlands for your set-aside area, but you don't get to use it when you're calculating your density that you're allowed.
Yeah, it wouldn't seem to make much sense
Yeah.
otherwise.
Right, you can't use it
Otherwise, somebody
anyway.
that had a huge swath of
Right, you could get,
of wetlands would then have a overly dense.
right.
All right. A couple of more uses we can just kind of take a look at is a commercial riding stable is allowed in the prime agriculture, the countryside zoning district, but not the estate or small estate. I don't think we have a lot of commercial riding stables right now in the town of Sevastopol. Potentially might have 1 or 2. A manufactured home park is a conditional use permit in the countryside zoning district, but is not permitted in the other 3. One thing that Mariah talked about was the single-family residence separated from a farm parcel. If you did have a farm parcel and that parcel was potentially rezoned to small estate, you no longer have that option. But with the small estate zoning district, it's now a 1.5 acre lot district, so you could split that house off on 1.5 acres. So you still have that potential to be able to split the farmhouse off. It just would be a different mechanism.
Just to reiterate the one thing that Kay said, so when you look at this, obviously single-family uses aren't listed here, but that's because single-family uses are allowed in all those districts. So the uses that are allowed in all the districts, we didn't put on these charts.
Right. We potentially have, I think I can think of 1 or 2 maybe. I'm trying to think of examples as, go ahead, Drew,
Okay.
as I drive through the town. We have a couple of sawmills or planing mills. They're allowed in the prime ag and the countryside district. If they're rezoned to the small estate, they become not permitted in that zoning district. So these are just kind of a couple of examples of uses and the potential differences within those 4 districts that we're talking about tonight.
What's going to happen to these permitted uses that may be on the property now if it's divided down to small estate and they're no longer permitted?
If it's rezoned, that's what we're going to next.
Exactly what I'm going to talk about next.
Yep.
So in zoning lingo, what that's called is if you have a use or a structure that when it was authorized, it conformed, it was legal, it met all the standards in existence at that time, but then either the rules or the maps change, you then become non-conforming. So you don't meet the current standards either because, I don't know, whatever, that use isn't allowed anymore, or maybe you had a different setback in your old district or something like that. So a use of property is non-conforming if it doesn't meet current standards, but as long as the use was in compliance with whatever regulations were out there when it was established, it will be grandfathered. So it can continue forever. You can continue doing exactly what you're doing forever. But if you want to expand, then you probably are going to need a conditional use permit, which, as Kay said earlier, is a public hearing before the Resource Planning Committee. in order to expand, because expansion of a non-conforming use requires that public hearing and that conditional use permit. You also would potentially lose your grandfathering status if that land use ceases for more than 12 months. So if you had a sawmill in a district where it was allowed right now, you got rezoned to small estate where it's non-conforming, your sawmill can continue forever. But if you stop running the sawmill for 12 months, somebody can't start it back up again. And that grandfathering, yes?
What if you sell it?
That's exactly what I was about to say. That grandfathering status stays with the property, not the owner. So if I have a non-conforming use that's grandfathered and I sell the property, the next person can continue that use exactly the way that I was doing it. They, again, if they were going to expand, would need that conditional use permit, but they can continue doing exactly what I was doing. So it goes with the property, not with the owner.
Mariah,
Yes.
in small estate, agriculture is not permitted.
Correct.
If we have using our example, for instance, if we have an agricultural enterprise now, we could not buy adjoining property and start farming that.
If it was in small estate and it was not being farmed right now, then no, you wouldn't be able to do that.
What if we had a fire, then we rebuild?
If you, okay, and that relates to the structure, but if you had a fire in a building that was housing a non-conforming use, I think we would let you, you get to rebuild exactly what you had.
What if we renovated an orchard and it took 3 years to rehabilitate the land and replant trees? Would that be outside your 12-month period?
So it hadn't been used in agriculture before that, or?
Yes, no, it had been an orchard.
Okay.
We cut those trees down, pulled them out, reconditioned the ground. It took us 3 or 4 years to do that.
I think we would still, I mean, as long as you kept us apprised of what you were doing and we knew that, you know, you hadn't
That's
just
part of the
cut the trees down
process,
and,
yeah.
that would be allowed. I want to quickly, before we go into a couple examples of non-conforming uses, yes?
Just one more question on that, like that sawmill example. When you said that you couldn't expand, how do you define expansion?
The ordinance says if you're going to build a new building, or basically if you're going to intensify the use, that one can be a little bit harder to quantify, but if we have information that, you know, the sawmill used to run 2 days a week and process, you know, X number of, I don't know what the quantity is, cords of wood, and now you're going to be open 5 days a week and process, you know, 5 times that, then that would be considered an expansion, even if the building itself isn't getting any bigger.
Or if you got so big that you did need a second sawmill, and so you wanted to build a new building with a second sawmill, that's another example of expansion. That would.
So building a building on a current agricultural enterprise would be expanding that.
Correct.
Correct.
Yeah. I mean, if you're, sometimes if you're doing something that, I don't know, I can think of a better example for like a multifamily development. So if you've got a multifamily development and they want to enclose, like, they want to add like a little utility room or something like that, where it's not actually intensifying the use, like you're not adding any new bedrooms, you're not adding any new dwelling units, things like that, we wouldn't require a conditional use. But if you're actually expanding your operation or the intensity of your operation, then you would need that conditional use permit.
Yeah, I have a good example for you. You have a very large building for your production of the produce, the apples and the storage, and you came to me and said, you know, we want to put a little entryway on for packages because when the FedEx guy delivers them, it gets in the rain, we are going in and out. That wouldn't be an expansion of the use. If you wanted to build a 20 by 30 addition onto that for additional processing, storage, et cetera, that would be an expansion of the use. So there's teeny little examples of what doesn't intensify the use, a small entryway coming into the building because you're having rain issues or something like that. But if you're going to add on to the building or put new buildings on for the agricultural operation, that would be an expansion.
We have a couple more examples we'll walk you through, but before we do that, I'll explain briefly the conditional use permit process and fees. So a conditional use, and like Kay was showing in that chart earlier, anytime there was a C in that chart, that means that use is allowed in that zoning district with a conditional use. And same thing, if you are a non-conforming use and you want to expand, you're required to apply for a conditional use permit. It's a public hearing before the Resource Planning Committee. That's 5 members from the county board. It's a $450 fee, and the process takes roughly 2 to 3 months, because what we do once we've collected the application and fee, we send it to the town planning committee for them to take a look at and meet with the applicant if the applicant chooses, and then give us, the county, input. And then we have to follow the statutory notice procedures, and so it takes about 3 weeks at least to get that hearing scheduled at the county level. And then there's a public hearing at the Resource Planning Committee, and then they make a decision about that conditional use permit. Most conditional use permits are granted, but not all. So there is the chance that a conditional use permit might not be granted. I can't, off the top of my head, think of any non-conforming uses that have applied for expansion that have been denied in the last at least 7 years. I can't think of any, but it's possible, I guess. So we'll give you 2 quick illustrations here.
Yeah, one of the, and this kind of comes back to what your question was in terms of farming. Property owner has 40 acres, zoned prime ag, only 20 of it's being currently used for agriculture. The property's rezoned to small estate, making agriculture a non-conforming use, and you want to expand into that other 20, or possibly you acquired 100 more acres that has not been in any type of agricultural production, and now you want to start farming it, whether it be cattle, cropping, etc. That would require a conditional use permit, because it would be expansion of that non-conforming use that exists. Another example would be a property owner currently operates a home business out of their home. A home business is permitted in a lot of the other zoning districts with either a regular zoning permit or currently a conditional use permit. The property is rezoned to small estate. That home business now becomes a non-conforming use because it's not permitted in that zoning district. The property owner decides to construct an accessory building to now relocate the home business into the accessory building, which is permitted under our home business designation. But that building may only be authorized if a conditional use permit is granted, even if the building is no larger than the area that was being occupied in the house. And one thing I want to talk about that kind of came to mind today, we don't have a slide for it, but as I was driving down the road looking at some horses, for some reason, this is the year of the horse. I've had more horse calls this year, actually probably the last 2 years, which is interesting. People enjoy having horses and like horses. The small estate zoning district does allow for horses. It's considered a private riding stable in the ordinance. However, you can't have horses on a 1.5 acre lot. So if some land was rezoned to a small estate and I purchased a 1.5 acre lot, build my house on it, and I want to have horses, even though it's allowed in that district, you need 2.5 acres to have a horse with at least 40,000 square feet of open space. So it's just something that kind of came to mind as I was driving down the road today. So there are other things in the ordinance that are still permitted in the small estate zoning district, but may have other requirements that you would have to meet in order to do it, or not be able to do it on that lot.
All right, a couple more slides and then we will be done. Oh, and that reminds me, I guess we ran out of handouts, but if anybody wants handouts, see us after the meeting and we can either send you one or maybe we can get one posted on our website. So process-wise, and this on the slide is general information about a change to the zoning ordinance, either map or text, but I'll kind of tie it into the process that Sevastopol is going through right now. So the town is obviously holding this meeting to gauge the level of interest in potentially doing some rezoning in either Institute, Valmy, or around the city. We will take information from all of you, and we've also had people that have been calling us already to give us information about how property is being used, whether they're interested or not. Our analysis as to how or if your property might be affected if it went to a different zoning district, we'll give that back to the town to look at. It's probably, given how many people are in here and the number of calls we've had, I'm guessing it's going to take us weeks to put everything together. And then the town, we've recommended, I mean, they'll take a look at what we give them and make some decisions about how or if or where they're going to proceed. I've had some people calling saying, if we don't want this to happen, is it going to? And I guess that's up to the town. I think from meetings that we've been at, you've been indicating that if people have said, we don't want our property rezoned, that likely it wouldn't be, but that's, I guess, a policy decision. And for those that are interested in having your property rezoned, it doesn't mean that you're automatically going to be rezoned. The town needs to look at where you are and what else is near you and everything else. This is just to try and get a feel for the interest so that then they can go back and analyze that with all of the information that we give them. So we've recommended that after this meeting and after we get all the information to the town planning committee, that they probably are going to want to have one more meeting where they would invite everybody whom they've decided to rezone so that they can talk with you about the process and make sure that everything's still okay with you. And then after that, then an application would be submitted to the county by the town with the list of properties that they would like to rezone and what they would like to rezone them to. As I said earlier, we have statutory notice procedures that we have to follow, so it gets published in the Advocate twice. It's a public hearing that is also held, just like a conditional use permit hearing, before the Resource Planning Committee. But in the case of a change to the ordinance, either the map or the text, the county board actually makes the final decision. So the Resource Planning Committee holds a hearing, and then it makes a recommendation, and then the county board takes the final action. So that whole process, once we've given the town all the information based on everything leading up to and including tonight's meeting, and once they've met with all of you, that's on top of this process. But this process, once they turn in the application to us, is going to take roughly 2 to 3 months. Yes?
Is this at all time limited, or could we decide, assuming that the new regime continues, to avail ourselves of changing our, we could wait several years and do it down the road?
I mean, it doesn't matter to
In our
us, I don't know.
It may never happen.
Yeah, in our discussions, what we were looking for is input from the people of the town to see if there is a desire to have some development. We as a committee thought it would be prudent to possibly keep it in the areas designated in the future land use. And we also decided that, or have discussed, that we wouldn't do something, and we're not in a hurry. It was a matter of getting information, evaluating the information, presenting that result back to the town, presenting recommendations to the town board. Those are all separate meetings, a month apart, and if the consensus would be, if people think maybe another year, that would be part of our discussion on what we should do going forward.
If I could just add as well, and a good presentation, thank you, but there's no rush, we're not pushing, no one's trying to push it down anyone's throat of any kind. We're just trying to look and plan ahead and listen what folks want. We also want to avoid what the term is unintentional consequences. We don't want to make a mistake, forget something, so your input's so important, but it may not happen at all. But if it happens, it'll happen because the town wants it to happen, the people want it to happen. It's not going to get pushed.
I have a question. Is it possible that, this is an off-the-wall thought, I guess, but say half the people want it, half the people don't, would we end up, in theory, going with spot zoning? In other words, the first half mile didn't want it, but the next half mile did.
That's a good question, and that's exactly why I said that if you want your property rezoned, the town may not necessarily automatically decide to rezone it for that exact reason. So if for some reason the only people that were interested were the people on the outer edge of the circle, the town might say, you know what, that doesn't really make sense right now because we don't want to have, a mile jump between Institute, I guess I'm putting it Valmy.
It could go either way, but we're not restricted to continuous, right? In other words,
Right.
Okay. That's,
Yeah, I mean, you could decide to do
we
that,
could.
but
I
yeah.
understand all the reasons
Yeah.
not to, I just want to know if you can go
Right.
both
And
ways.
one of the benefits we talked about with the county was, if we kind of lump them all together and say, here's the 50 properties that are interested, let's do this. The town implements the zoning change and they do the application to the county. Whereas if each individual would come forward, they'd each pay an individual fee where we're kind of exempt from the fee, so we could just take care of everything as once as a planning tool.
Right, I was going to mention that as well as part of this process. The county board, when it adopted the fee schedule that's in place right now for the planning department, when they adopted it 4 years ago, they made a policy that towns don't need to pay zoning permit application fees as long as that permit is for a town project. So like this town hall, I don't think, or was that before 2009? So a town project or something along the lines of the purposes of implementing the town comprehensive plan. So as Pete said, the town's rezoning application isn't going to cost anybody, any individual property owners money, and it's not going to cost the town either. Down the road, if for some reason you're either not included in the list that the town comes up with, or you didn't want to be, you always have the right as an individual property owner to petition to rezone your property. There are certain considerations that the county has to take, legally has to take into account. So if you are, out in the middle of nowhere of prime agricultural and you're not near any other smaller residential developments, it's probably unlikely that your property would get rezoned, but you do have the right to petition. But that is same exact process that's up here, and if an individual property owner is applying, it's a $550 fee.
Mariah,
Yes,
I've got
George?
a couple questions. The first one is, and I think I got the answer from the committee over there, what was the basic reason for these, for this whole reviewing of the zoning? Was it just to look into the future? And did you have any idea as that there's some demand for the lots that we're about to create? In other words, are there people waiting in line to buy lots in Sevastopol? Do we have to do this now?
Right, no, there is not.
There's not, there's nothing whatsoever.
No.
So it's just, no property owner asked for this?
Right.
This is simply something that...
Yeah, just to clarify, nobody on this board has property inside these circles, as far as I know. And part of our smart growth objective is designate where growth should be in your town, and these circles indicate where that should be. Part of the goal, as far as anything close to the city, is, my opinion is, if the town wants to preserve their tax base, we don't want to see the city grab all the lands, because the people don't think they have an option to do smaller lots.
Wow.
So that's part of the goal. The stuff, again, the school, the affordability, if somebody's looking right now to buy a 20-acre lot, I don't know what that's going for, but I'm sure it's $100,000. What person can afford that, build a house and be part of the school system? It's difficult.
I think there are other forces at work at that too.
Yeah, and one of the,
price of land.
when we first developed our smart growth plan, the planner that did that, they had done a projection on what's the growth potential in Sevastopol over the next 20 years. And that number was very small. It was 10 people or something. So certainly we don't feel like by doing this, Sevastopol is going to become a boom town and all these people are going to develop. The market's not there. There's lots available. It's just someday if people want to do this and the market comes back, the opportunity would be there.
So what you're saying, basically, there isn't a single property owner in this proposed district that's petitioned for any zoning changes?
Correct.
Okay. When is the effect of these changes going to have on the farmland preservation program?
I can speak to that. The county is in the midst of updating our county farmland preservation plan. That's a state mandate. I'm not going to remember the year they adopted it. They keep moving the deadline, but now our deadline, and we're sticking to it, is that our new farmland preservation plan for the county needs to be completed by 2014. We're actually folding that farmland preservation plan into the comprehensive plan because the statutes require the same exact process to adopt both, and rather than having two different planning processes bouncing back and forth every couple of years, we're going to do one plan. So what we're doing with the farmland preservation plan is we are taking the county future land use maps, and anything that's mapped on the county future land use maps as rural or agricultural, and anything that's woodland, wetland, natural area, unless it's owned by like the Land Trust or the Nature Conservancy or the DNR or something like that, those are the areas that are going to be mapped as farmland preservation areas in that new plan. Now, for those of you that may be farming that are under one of the remaining individual contracts with the Department of Agriculture, Trade, and Consumer Protection, those contracts, once they expire, you don't have the option of renewing them anymore. The state changed the law. So once those individual contracts are over, they're over. The only way under the new program that you can get tax credits is if you're in a certified exclusive agricultural zoning district, which in Door County, the only town that has that is Claybanks. Or if you're not in that district, or even if you're in that district, if 5 or more contiguous property owners who own roughly 1,000 or more acres collectively apply to the state to be an agricultural enterprise area, you can then collect the tax credits through a contract that's similar to those individual contracts that have been in place for decades. But you're no longer going to have the option as an individual farmer to be in those contracts. So I'm not sure that that anything that the Planning Committee is talking about doing would really have any impact on anybody that's in a contract right now, or on what might happen with the future of farmland preservation.
When that circle was laid out, did you have any idea about the effect this would have on the zone of contribution?
You're talking about these circles, George?
The circles that are laid around.
For the mailings?
For city
Did it have
wells?
anything to do with it?
I guess one question, or one thing that we should say is anything that would be rezoned into small estate would be on its own septic system. Each individual lot would be. There is not capacity. We're not looking to expand the institute facility.
No, but the zone of contribution is the area that's been designated.
For the city
as
wells?
As far as the city wells?
That contributes to the water supply of Sturgeon Bay. And that area has been designed, and it runs right through a corner of the land that you intend to, or that's proposed to be rezoned for small
Sure.
lots. Now, there are some pretty strict soil and water conservation measures that are required in that zone of contribution. And apparently that's never been considered at all in drawing the line.
No, not yet.
No, okay.
We could do that, though. The county, we've got a digitized version of those zone of contributions areas, and we could lay that on top of the map and give that to the planning committee
Right.
with our information.
All right. One more question. I guess that's it. Yeah, my personal feeling is, and I own land that's gonna be involved in this. My own personal feeling is I don't like it and I don't want it. I think, and I've been on the zoning committee for about 10 years, and the one thing we didn't want is spot zoning. It looks like me, this is an invitation for spot zoning. You're gonna have a little lump of houses here and a little lump of houses over there. Residential districts in the midst of agricultural, particularly practical agriculture, it is not a great inducement to have people building their houses where you're spreading liquid manure at the rate of 5 or 10,000 gallons to the acre. I mean, there are some disincentives of living in the country. And I think to combine this idea, I think dairy farmers are getting bigger, and they've got issues to dispose of their waste. And if you're going to put these little cute little housing setups around and have somebody spreading manure around them, they are not going to be happy campers. And it's going to raise hell with the farmers, because they're the ones that are causing the problem, even though they were the ones that were there first.
Right.
I think this whole concept, in my opinion, is an invitation for spot zoning and community confrontations, and it's not my idea of smart planning.
One of the things that we had talked about with the planning committee back when we met with them in February were some of the concepts that you're talking about, because some of the ideas that were being batted around were maybe we would just let some larger landowners rezone, and that was the county's comment, was that you don't want to have a subdivision here and a subdivision there and one here and one there. And so among the options that we presented was the idea of, why don't you look at the areas around your core areas. And they decided, just for informational purposes, to just, let's do a mile radius to look at the idea. And maybe a mile isn't going to make sense. Maybe they want a quarter mile, maybe they want a half a mile, or maybe they only want to do the east side of something. So I think it was more just to get information and input at this point that they drew the circles that way.
One final question. in laying out of this district, has there been any consideration for the expanding of the Sevastopol sanitary district to service these septic tanks that are gonna be scattered around these little groups? Have they got the resources to expand their pipelines to?
I don't,
No, this would not be tied into the sanitary district.
Well, how are you going to service the sanitary district of these little groups of houses where you've only got about a foot of soil?
Each lot would have to be suitable to put an on-site septic system on it.
Then it might
And
not
if
work out to put these little houses all together.
Well, right, you pick the areas with the better soils
I
to
mean,
do so.
you're not gonna service them with conventional sanitary systems, because in a lot of, I've been living in that area all my life, and I know full well, there'll be 6 feet of soil over there, but there'll be, practically no soil here. And you can't very well put the house where there's no soil.
Right.
And so,
Right,
unless
certainly.
you can service it with a sanitary district, I think the whole idea of building these little clumps of houses is almost ludicrous.
I disagree.
Maybe you do.
I feel if you have 100 acres, if you have 100 acres, and you're gonna put 20 lots on it, and you have 20% of your 100 acres that is suitable for sanitary,
Yeah.
septic disposal, that's where you place your homes and you preserve the remainder.
Oh, and then use all the good farmland for houses.
There's plenty of farmland that's being farmed in this county on a foot of soil. Orchards, everything.
You think
I guess I
there are-
wouldn't argue that you can't put residential development in the town of Sevastopol because of the soils.
You would argue that.
Correct.
there's a gentleman that's had his hand up in the back.
Question for Pete. You said earlier that sort of the question tonight was that mile radius or that mile area too big or too small?
Right.
How did you, first of all, how did you determine that a mile was a suitable size? And has there been any calculations relative to how many buildable lots that would generate if that area was rezoned? I mean,
Yeah, at this point, the mile, we discussed the mile
Just an arbitrary.
for an hour. Should it be a mile and a half? And we just picked a mile. There's nothing magic. We just wanted to get it out there and get reaction from the community. And we felt the mile would get us this room full of people, which was great.
in my opinion, the mile would be too much. I mean, I didn't calculate it here, but it seems like it would, if you look at the size of Valmy now, it's maximum a quarter mile from one edge to the other, and now you're gonna, increase the size of that, developable land in that area. It just seems that it would be way more than we'd ever need. And I don't own land that would be subject to the zoning, but that circle would come within a quarter mile of 40 acres that I do own in the township. And that land was purchased primarily for outdoor recreation in a rural setting. And so if you took probably a lot of that property around a mile perimeter, again, you're affecting a lot more people that would have received mailings, because they were gonna be possibly directly rezoned. And so I think you have to take that into consideration. I don't know what the proportion is, but if you shrink that area down, I understand and I agree with the fact that if you're gonna do growth, that it should be limited to a certain area designated for smaller lots and growth. And it does become, as George said, a bit of a spot zoning, and if it was, as Mariah mentioned, the people on the perimeter of that mile circle, it would certainly be somewhat spot zoning. So, in my opinion, that mile would be large. Should be probably smaller, but I agree with the
Right.
concept of limiting the growth to a designated area so that you do get more concentrated, smaller lots rather than have them scattered all over the place.
Right, well, what we didn't want to do at this point was limit it too small so that there's a farmer 3/4 of a mile out that says, I'm gonna hang it up, my kids don't want the farm, I'm gonna split it up. Right now I can split it into 3 lots. Maybe this would be a great opportunity if you wanna rezone it. He could make his land more valuable. So we didn't wanna exclude anybody that we think maybe would be interested. Again, yeah, maybe the answer is let's go half mile. Maybe that's exactly what we find out.
If you use that line of thinking, then it should be township wide. why exclude anybody at that point in time? I mean, there's gotta be an
Yeah.
exclusion, but you gotta pick a point, which would be the center of Valmy or center of Institute, and go out from there, and how far you go is pretty random. I mean, I think you need to look at it more in terms of how many buildable lots might this township or these areas that are already residential require over X period of time, and go with that, and if you're excluded, because otherwise, if you're not trying to exclude anybody, it's gotta be township-wide, and that would not be good.
I just want to interrupt really quickly. I saw at least one person leave. If you don't want to stick around tonight, or you can't stick around tonight to fill out the forms with either me or Kay, if you got one of the handouts, our contact information is on there. You can call us, and we can do it over the phone. And also, the website is on there, and like I promised, we'll put this PowerPoint presentation up on the website. It'll be up there by the end of the day tomorrow. So, but that's. Were there other questions? I thought I'd seen, yeah.
Kind of a mechanical question. I just never quite understood how this worked. So let's assume that there was some sort of rezoning that did occur. Does the rezoning apply directly to the property as it exists once the zoning occurs, or must a transaction or some event occur before the new zoning is applied? It's a real simple example. You showed the small estates not supporting agricultural production, right? The property that's currently being used for agricultural purposes is rezoned. When does one stop being able to do agriculture on that, agricultural practices on that land?
You don't have to stop doing agricultural practice. You can continue as long as you're doing it essentially in the same manner, essentially in perpetuity. If you decide to change or
But if I bought some land next to me, then I would be in trouble.
if it was zoned small estate, correct. Not trouble. You just have to do
You
Might
just-
be trouble getting about my use of the land.
Right.
Well, if it was a separate lot, they wouldn't be able to establish agriculture,
Well, they could do it as an expansion of non-conforming use
even on a new lot.
if they combined them.
Okay,
Yeah.
sorry.
You
Yes,
said earlier that in an ag situation where a member of the family wanted to have a separate dwelling on the farm, or an employee wanted to put up housing for an employee, if that status changed, grandma and grandpa quit farming, they're now living in a smaller home on the farm, they pass away, what happens with that home? The employees, you had two homes, you only need a home for, you only need one home, because you don't have that many employees. Do you have the option of then renting that home or selling it off as a separate lot?
yes, yeah. I think what you're talking about is when you split your house off onto a separate lot, or if you're creating vacant lots for your parent, child, or employee as a farmer. Initially, when you do that, you need to show us that it's going to a parent, child, or employee. But after that, I mean, you can turn around the next day and sell it. And I don't think anybody's really been abusing that provision over the years, so we've just left it that way, that we trust that you're going to do with it what you say you're going to do with it, and then once that person no longer lives there or needs the house, then you can go ahead and sell it or rent it. So we don't monitor it in perpetuity. Was that your question, or were you asking about the temporary?
That's
Okay.
my question, because
Yeah.
I know of a number of families that do have a parent, grandparent, or whatever that's living on the farm, on the home farm, in a separate home, but I don't know that that parcel is deeded as a separate parcel.
Right. I can speak to that because I know and have worked with many farmers who have that situation. You have a single family residence on the farm, possibly the son and daughter lives there. The parents live in the other farmhouse that was established on the farm. However, they only have 38 acres. Those homes could not be split off onto a separate lot in terms of, it being 220s, but you could separate off one of the homes as the single-family residence, split off, no, actually you couldn't. Yeah, you could, because you still would have the 20 acres left. But if you only had a 20-acre piece, that's where there would be an issue in terms of actually selling one of the homes, because
Well,
then you didn't have enough
If you could meet the
acreage.
conservation subdivision requirements, though, you could. If
Right.
you had a 38-acre parcel that had 2 houses on
Yeah.
it, and you could set aside the open space and split those off, it's possible that you could still do
You could
it.
do it that way.
Got the old farmhouse. Next to it, there's less than less than an acre, but certainly enough to put up a modest home for grandma to move into. So we put up that home, grandma moves into that home, 6 months later she passes away. Now we got less than an acre lot, that's part of the farm, but what are we gonna do with that home? Grandma's gone.
You can sell it, you can rent it, and if you didn't put it on its own separate lot, I think, depending on what you had developed and constructed, you'd have a variety of options. And that's why we spent as much time as we did walking through the secondary dwelling unit and the conservation subdivision options and that type of thing. So if you're gonna build your home, a home for grandma, maybe grandma only needs 749 square feet to live in, and you don't need to put it on a separate lot. You can attach it to your house, or it can be, attached to a garage, or it can be its own separate standalone residence, and then it doesn't matter who lives there if you do it under the secondary dwelling unit
And
regulations.
if somebody does have a specific situation that you want me to look into, I'd be happy to do that. You can call the office, give me, your tax parcel number or address, and ask me to look into specifically that
I'm thinking
situation.
I know that there are families here in the township that have situations like that, and I just was puzzling over, at some point, that home may be available, and what are their options? And so what I hear is, they could carve out less than an acre lot and sell that off.
Not less than an acre.
1 acre.
Yeah. There's potential for a variety of options. Each situation is going to be a little different based on how much acreage is in the home tract to start out with. But so kind of the variety of options we walk through on the slides would be something that could potentially be looked at. But if somebody does have a specific situation, call me and I can go through it in the office.
To the committee, and then a couple of general questions. Did this start with our coloring, when we colored in? Okay, so for those who missed it, 5 years ago, we had a chance to begin this input. And this is the result then of the desires of the majority who colored the maps out. And for me, I say that's good forethought, and that's, planning is important, or you end up with nothing. The other thing is, this gives the landowner, George, I'm thinking of you, the option to direct what can happen to your property in the future. But you are not obligated to do that by putting in small estates or countryside. You don't have to change your use of the land, doesn't change your tax basis at this point as long as it's used. Is that correct? Within 12 months? So it gives you a great number of options in the future as you decide to not farm or pass it on to your family and let them decide it doesn't lock you in. Is that the idea here?
Right, and maybe the answer after everybody does the survey is small estates too small, we don't want 1.5 acre lots, we want 5 acre lots or 2.5 acre lots. That's everything we're gonna be talking about in the next couple of months.
It gives the landowner flexibility
Right.
and control. And then the other thing is, and just a suggestion, if you had an open-ended, say 5 years to sign up for your zoning change, or more than a year or more than 3 months, could that be done? So that the town could leave this, give us time to think about it and,
Right.
see what's happening to the neighbors.
Right. We got to the point in our process where we've gone as far as we can without public input, and that's why this meeting's being held. So after we compile the notes from tonight's meeting, we're either gonna say, it's dead, see you guys later, or let's keep moving on the process
Would
somehow.
that work with the planning department?
I mean, it doesn't matter to us how long you want to take to make these decisions. And once the town turns in its application, then that's the application, and those properties that are on there are the properties that are on there. And after that, if you weren't on that list, then it would be up to the individual property owner to petition to rezone. But like Pete was just saying, one of the things that, maybe if people think small estate is too small, well, in an ideal world, when planners draw things on maps and they color things, What you would do ideally is you would move out in terms of the intensity and the density of the uses. So you would take your core area and you would figure out some reasonable boundary, and you'd make that small estate. And then maybe out from that, you would make that a state. And then maybe out from that, you'd have countryside, and then you would go out to prime ag. But in reality, that's not what happens. Usually, that's not how.
I guess just to comment on that, if you would be zoned small estate, that doesn't mean you can't make 5-acre lots. It's just the minimum lot size is smaller. You just can't go, yeah, it's the tightest zoning you can.
It'll be the uses more than probably the size that might dictate the desires of individuals.
Okay, go ahead.
I have 37 acres in forest management, and I'm right near the core of your circle. My 25 years is up, I have to renew or not renew. Am I going to have that option?
To be in the managed, I don't think that the managed forest law program looks at how your property is zoned, as far as I know. I know that they are going to, I mean, just like the contract that you're under now, probably you have to designate if you want to pull any of it out to put a house on or something like that. But I don't think that they care how it's zoned as long as you're cooperating in the program.
I'm not in the plan, but what I'm more concerned about is when my plan, I just renewed my plan a couple of years ago. So when my plan comes due again, am I going to be able to do it if it's all rezoned to 1.5 lots?
That's a program that we don't administer. You might want to call the forest management person that you deal with, that you just renewed the contract, and asked if the zoning designation makes a difference with regards to placing lands in the program.
Do you usually deal with either Bill Ruff or Chris Plazik? Okay. I mean, we could, if other people have that same question, we can certainly call and post something on the website too.
There might be a little confusion there that the zoning does not set up the 1.5 acre lots. You have to divide your property.
Right.
If you don't, you still own the 40 acres or whatever it is.
Right. He's just asking for his forest management program, though, if he would still be able to enter if there's a zoning change, if the zoning district would dictate whether lands could be probably placed again into that program.
Just because there's 3 circles on that map does not mean that each one of those areas has to go at the same time. Maybe the people around the city of Sturgeon Bay would like the rezoning and the people around Valmy don't. Sturgeon Bay may get it and Valmy won't.
We can give either Bill or Chris a call and find out the answer to that question, and then you can either call us or we'll forward on the information maybe to Linda Waite, and then she can pass it along to the board and planning committee members. And like I said, I don't think that how you're zoned affects those contracts, but we can check.
Margaret had a question.
Well, we keep talking about we have to do this because there may be some people that want it and some people that don't. And it seems to me that we worry so much about the future. And this is very important. But now we have an 80 acre piece of property. And our kids may get it or we may sell it. Now, if whoever we sell it to decides, hey, there's a bunch of money here, all we have to do, well, we already have this land surveyed, and on this land, and you were the one that put it on there, there's 4 places that we can build houses. And there are already 4 houses on this 80 acres with septic tanks. Now we're gonna be able, or we would be able to, we have no plans of doing it, but somebody, like I say, in the future, they don't really think about, you know, a lot of people don't understand the soil, and the soil on this piece of property is not 3 feet deep. In some places it's you know, a few inches. So I just don't think that we should have this, this option for these people in the future. We don't do it, and they want to do that, because we already have one family that doesn't live on this 80 acres, but he's right over the side. He has no good water. They've drilled, I don't know, 3 wells, and it's still bad. And we're also in that area of Sturgeon Bay's water supply. So we're not supposed to spread manure and do things at certain times.
Well, do you think that we should put 8 septic tanks on that 80 acres of land? I don't think we should provide that possibility. I don't think it's right. And even if we decide not to do it, I understand we're the ones that are gonna make the law. And what about the people in the future? I just don't think that's right. We
Margaret,
got too many septic tanks already.
I think you've got a really good point, and that's why we're having the meeting, because we couldn't think of all the points, because we don't have each one of the situations that each of you has. So if you are going to fill out one of those papers, if you could just, we're trying to take notes too, Pete's writing like crazy. If you could just make a mention about that, too many septic tanks in the area, and that will help refresh our memory. Just like the gentleman that suggested that we limit the number of lots rezoned to the number of lots projected to be needed and concentrate them near those core areas. I think I summarized what you said. It was a gentleman in the back. I can't see him because he's right behind Laddie. But if I got that right, that's also a good note that we made down. And so when we get the results of this information that you're going to provide us, the additional information that you're going to provide us, then we have a better basis for a discussion.
Yes.
Pete, in your letter, you, I think, indicated that some of this effort may be directed to maintain the integrity of the town boundaries from city property encroaching. Does the city have interest in some of this adjoining land? I think several years ago I saw a city map where they did have some interest in town property. Has that gone anywhere? Have they, is this a movement that the city has?
We haven't had the city involved at this point. You know, I know the city does have extraterritorial jurisdiction as far as approving and not approving land divisions. So we haven't gotten to that point. I'm sure the city would love to expand.
Yeah.
Most cities do.
But like the town, there's really no demand for city lots like there would be for town lots. I mean, it's the same demand, either the city or the town.
Well, I think the demand for a lot near the city but on town taxes is desirable to most people.
Mike?
Hi, my name's Mike Carr. I understand the planning commission's difficulty. I was on the planning commission in Liberty Grove, and we went through the whole smart growth process and everything. It was a very difficult thing. And I will tell you, smart growth is a great idea. It doesn't hold up in court. Correct me if I'm wrong. Liberty Grove did a conditional use permit using smart growth. We denied the permit. It got challenged in court and it lost. The only thing that really holds up is zoning, and good zoning. Smart growth is a great idea, but you have to follow through and do the zoning. So you have to put a lot of thought into your zoning to adopt it and everything, and work with the county to make it happen. I will tell you this, I just bought 20 acres this last year from George and Margaret, and I was 20 years up in Liberty Grove, and it's too developed and everything, and I moved down here for the rural character. And I'm possibly going to purchase more properties than George and Margaret. And we have to think about what we truly want to preserve here as a rural character. And you have to have smaller lots. Maybe I'll subdivide it. Maybe my kids want to subdivide it. But to have a cookie cutter approach and do it all like that, and I'm in that 1 mile zone, it just doesn't make sense. If I had known it was zoned that way, I wouldn't have bought here. I bought here for the rural character. I want my 20 acres. Yeah, maybe I want to be selfish and say I don't want anyone else. I still can subdivide parts of it with the commercial, and we've talked about this. It's okay if you go down to 10 acres, right? 2 lots on it if I wanted to, which I think offers a lot for your zoning out in the country. Maybe that's even too much. I don't know. Personally, I think 1 mile is way too big. I think the lots you should be looking at are much smaller, and it should be on a case-by-case basis, on a parcel by parcel, which I know is more work for you, but I think you should allow the developer or the landowners to come up to you. You should also look at the sanitary, making sure those lots are compatible with sanitary and utilities.
I appreciate those sentiments. I mean, that would be my personal preference too. But I think there's a value in not constraining the choice of other people. There's value in that too. This is maybe the first time I can remember where a governing entity is actually increasing the choice of the citizens, if I'm understanding this correctly. This is my first exposure to this. But I trust my neighbor's desires to not decrease the property value of the property. And I'm not expecting Potter bills to go up all around me and that sort of thing. If there's a chance to have choice in the zoning, I, as a citizen, would rather make a choice personally in the zone type that I live in rather than have a governing body make that choice for me.
I want to step in there. You have to be very careful that people don't get to pick their zoning. You can start getting into all sorts of legal problems if the town is going to let people pick how they want to be zoned. And that's why I said before, they're just trying to get input as to whether or not people are interested. And just because you're interested doesn't mean you're going to get rezoned. So, and I'm not a lawyer, but you can get into some legal issues if you would actually let people color on the map.
So, presently, if it was prime agriculture, what's being proposed is that the governing body would be able to change that zoning to a different type that the landowner could elect to execute or not.
Well, the petition to rezone would be turned in by the town, and then, assuming it worked its way through the process and was approved, your property would be rezoned, or whoever's property it is. So the election part is whether or not you choose to then subdivide it in accordance with whatever that new district is, or use it in accordance with that new district. But yeah, I mean, like I said before, I don't think this is going to happen, and it's an extreme example, but if the only people that were interested were a couple of people on the fringes of each of the circles, the town might say, you know what, that really doesn't make any sense. It's going to be spot zoning. We're going to have subdivisions in weird areas, and we're not going to look at this for another couple of years or something like that. So, yes?
So could it ever be rezoned down to like just 10 acres or 5 acres if you
Sure.
owned 100 acres?
Yeah. Sure. And that was one of the things that we had talked about with the town as well, was that when we get information from all of you, which we should probably start doing soon, because otherwise we're going to all be here all night. But like I said, you can call, and we can do this over the phone as well. If you're farming right now and you are thinking that in a couple of years or even next year that you might want to be building a new barn, or you might be expanding your farming into a part of your property that you haven't actually previously cultivated, and so you're really nervous or not interested in that small estate zoning district, we could look at either that estate, the 5-acre district, or countryside, the 10-acre district, as an option. So maybe instead of prime agriculture, you could give your input to the town that you'd be potentially interested in one of those other districts, because then you could continue your agricultural operation as a conforming use and not have to worry about the potential conditional use permits. So those are certainly options. Like I had said before, in an ideal planning world, you would kind of move out from the center with the districts getting progressively larger, but
and
it
once,
doesn't usually work that way.
Right. Once we get the sheets back with regard to like what's on your property now, what's your current use, and we kind of summarize, go through each of those, and present that back to the planning committee. All of your input you should be providing to the planning committee as well, or we can write it on the sheet, either over the phone or tonight. Then the planning committee is going to take all of those opinions and responses and our technical analysis of the current uses and whether or not it makes sense to go to small estate on some, or the majority, or all. They're going to have another planning meeting and discuss and figure out kind of where to go from there.
And our planning meetings are posted. So Linda Waite does a great job trying to make sure everyone gets a notice when we have a meeting. They're public meetings, and they're posted. Linda, do you want to say how you post them, just for everybody here? Although it looks, everybody here got a letter.
You're required to post, for open meetings law, that you do have to post notice of town board and commission meetings. So they're posted at Sevastopol School here at the town hall, Welsing's in Valmy, and Culver's near the city of Sturgeon Bay. They're also on our town website, www.townofsevastopol.com. You can find just about anything on our website, or feel free to call the office, 746-1230. And if you wish to receive a copy of the agenda, please let me know, and I'll be more than happy to add your email address to the agenda listing.
Does anybody else have any more questions?
Right here,
Yes.
you're talking, and I may be not understanding you right, but if it's zoned 20 acres agricultural now, and your first slide, you said there was exceptions, it could be divided into 10. That's what exists now. No?
If you're in the prime agricultural district right now and you own 20 acres right now, you would have the option of doing a conservation subdivision. That would be the only way that you could split that 20 acres, and you could have 2 small lots that you would create if you set aside 80% of your 20 acres as open space or farmland.
That's done through your group, and that exists now.
That exists now.
Okay, as far as for the other stuff, you can do this, maybe you can do that, maybe it's small lots, it's all or nothing, right? I mean, it's either all small lots or all the next size, 5-acre lots, or the way it is now. It's not the spot zoning. I mean, I get confused with what you're saying.
Spot sizes.
Like you have options, but you don't have options. It's either one or the other is what's going to be decided.
There are a fair number of options right now with what you have right now, depending on the district you are. You can, like we walked you through, you can create those conservation subdivisions. Depending on how much land you have, you can do a regular subdivision. If you're farming, you've got those other options as far as splitting off your house or creating smaller lots. But as far as the basic lot size requirements, that small estate district that the town is looking at is a 1.5 acre district. And then you've got the estate, which is 5 acres and 10 for countryside and 20 for prime agriculture.
But in the whole 1 mile area or the area of zoning, it would either be all of the 1.5 acre lots or all the 5 acre lots. There wouldn't be spots in between there.
I don't think so. I guess I'd let the town answer.
That's part of what we're going to process. Maybe the answer is.
Zoning, that's what zoning is, right? It's a control thing, so that's my question.
Yeah, I mean,
don't understand what the difference. Okay, I'm over my head.
No, I mean, everybody's in a zoning district now, and then the question or the issue is, do we want to change some of those areas? I don't want to speak for them, so they can correct me if I'm wrong, but when they asked us to draw maps that were a mile around each of these areas, I don't think that anybody on the committee thought that they were going to rezone every single property in those areas. But
and we didn't want to identify specific properties by creating boundaries around those properties. So that's why we did an arbitrary circle without identifying specific properties.
without a doubt, yes?
To follow up on this gentleman's question, suppose that I get rezoned, I'm in the zone, the 1 mile zone, and I get rezoned, and let's say I have 40 acres. Now, do I understand correctly that I could have some 1.5 acre lots in that? I could have some 5 acre lots in that? I could have some 10 acre lots in that? It's my choice?
Yeah, the small estate zoning district, let's just say you were rezoned, you have 40 acres, it's now zoned small estate. The minimum required lot would be 1.5 acres.
But I wouldn't have to have all 1.5 lots. I could have
No.
some 10, I could have some 5.
Right,
I could have some
correct.
1.5.
And I just want to speak real quick before we end here tonight about what land divisions. Door County has a land division ordinance. It's in effect in every single town regardless of whether or not the town has zoning. You can create 4 lots less than 10 acres by a certified survey map. Any more than 4 lots is considered a major land division and goes through a much different process than the sign off on a certified survey map. So yes, you could create a 5 acre lot, or you could create 4 10 acre lots if you were zoned 1.5 small estate.
Okay. Did anybody have any other questions? Okay. Like I said, if you don't want to stick around because there's a lot of people here, you can call us in the next, like I said, it's going to take us weeks probably to compile all this information, so you can call us in the next couple of weeks. Otherwise, we do have forms that we can walk you through right now to fill out. Should we ask them if they want to fill them out?
No.
Okay. We need to get the responses from you to fill out so that we can move quickly through the questions, because they're not written for the layperson to necessarily fill out. And plus, we've done things like this before where we couldn't read the writing at all.